Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or are your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orlin Johnson. Let me introduce you to our panelists for today. First, we have with us Mr. Vilo Weiss, who's the Director of Public Affairs and Religious Liberty for the Indiana Conference of the Seventh-day Adventist Church. We have Mr. Andre Wang, who's the General Counsel and Director of Public Affairs and Religious Liberty for the North Pacific Union Conference of the Seventh-day Adventist Church. We have with us also Ms. Bettina Krause, who's the editor of Liberty Magazine. And we have with us Mr. Rashawn Baker, who's the President and CEO of the Baker Strategy Group and a University of Maryland Professor of Public Policies. Great to have you guys here with us and looking forward to our conversation for today. You know, the Education Department of the federal government has proposed religious liberty and free inquiry rules. You know, a couple of years ago, the Department of Education issued what they called a free inquiry rule, and that was to add material conditions as it relates to First Amendment freedoms to require that in order for you to get grants through direct grant programs and also state administered programs, that there had to be material conditions that demonstrated that you were not going to be in violation of the First Amendment. And they wanted to make sure that private institutions would also be following those same policies as it relates to free speech. You know, when you think about these type of issues where now you have the federal government trying to figure out how to codify something so that entities and organizations will know how they can move forward, when you start reading in blogs that basically are demonstrating and that they are consulting with certain stakeholders, but at the end of the day, it still looks like they are going to be doing away with pieces of legislation that basically have been utilized to strengthen missions of religious organizations, but ensuring with this new rule that they're getting more of their hands around it and really, in my opinion, really determining what free speech is looking like. You know, Vilo, when you hear some of these activities that are going on and you see some of this language that's taking place, how do we end up trying to figure out how to deal with departments that are rescinding regulations because they think that it should be something that's necessary to, quote unquote, protect free speech?
I'm surprised that they're, but not surprised that they're doing it, because we've had issues with free speech in academia. You know, the Eighth Circuit found that the University of Iowa had disregarded free speech and decertified Christian groups there on that campus. We have the Christian Legal Society v. Martinez, where the Supreme Court upheld that the chapter didn't comply with the school's non-discrimination policy, and so it's interesting that they're saying, well, these things are not needed. Well, it's made life a little simpler for a lot of Christian groups, thankfully.
You know, Andre, how do you really try to help people to understand what this is really all about? It can seem very confusing. It seems like it's confusing to the Department of Education right now.
Yeah. So, this is called the free inquiry rule that was intended to provide protections for communities of faith on colleges and universities, that they uphold the First Amendment. In particular, the section there's a section in the rule that prevents higher education institutions from denying faith-based student organizations and even faculty organizations and clubs any rights, benefits, privileges that are also afforded to non-religious student groups because of their beliefs, practices, policies, and speech. And so colleges can be found in violation of this rule could lose access to grant programs, both federal and state, but not federal financial aid. So that there's that. And so really the idea behind the rule is that it gives protection to religious organizations and their student members and their right to religious free exercise. The idea of withdrawing the rule now is that this rule could be interpreted to require higher education universities and colleges to allow religious student groups to discriminate against other students, such as LGBTQ. So the position of the Department of Education is that this provision is confusing, unduly burdensome, and unnecessary, redundant. That it's really just belts and suspenders because there are already religious protections in the Constitution and in statute.
You know, Orlin, this whole discussion of free speech is fascinating to me because, you know, I think what we are seeing more and more in society, not just with this sort of wrangling over regulations here, but we're seeing equal opportunity intolerance from both the left and the right. And so, you know, this particular rule is being perceived as something that's protecting right, conservative Christianity, for instance, and so it's going to be rescinded. But, you know, increasingly we're seeing that even on the left, there's a lack of respect or understanding of the basic principles of free speech. I mean, there was an incident just a few weeks ago at Stanford Law where a group of progressive students shouted down a conservative judge from one of the circuits who was invited there to speak to the Federalist Society members there. And they shouted him down. They didn't allow him to speak. And I think really all in what this is showing is that this issue of free speech, and, you know, amusingly, those students had to go to a free speech boot camp to be reminded what free speech was about. But, you know, both the left and the right are guilty, I think, of trying to control speech in ways that allows them free speech, but not others. And so, you know, this wrangling over the regulations that we're seeing here is just maybe a symptom of this larger culture war that's playing out.
You know, Rashawn, this is just a question that, for somebody like you who's on a college campus, I mean, when somebody decides they want to create a club or a fraternity or a sorority, isn't it clear from the very beginning that this is going to be a group that is going to discriminate against somebody because they're making the selections as to who should be part of this club or fraternity or whatever? And then the idea that there's going to be this quote unquote, well, you should have this reasoning that allows everybody to come in. The whole purpose of a club is to make sure that everybody doesn't get to come in. Well, am I missing something here?
No, you're absolutely right. And I think that is the problem that we're having is trying to find that balancing act. Bettina is absolutely correct. In this new world we're in, and I support a lot of what is going on, opening up more opportunities and making this democracy wider and more inclusive for everyone. But at the same time, as you try to include more groups, you start infringing upon the free speech and free rights of other groups. And so it is that balancing act. And most of the time when you're doing legislation, it goes a bit too far. And I think that's where we start seeing it. You overcorrect. You had a regulation that protected freedom of religion, and then you try to rein that protection in to make sure it didn't exclude everybody, and now you've made it worse. And so it's us looking at this balancing act in our country, which is the problem where you see the issues throughout every facet of our government.
Vilo, it says that there's already some rules and regulations in place that should already be protecting without having to go this far. What are some of the things that should be out there that should be taking care of this? Why we wouldn't really have to go in and start really dabbling with some new rules and regulations?
Well, of course, we have the Constitution, we have the Bill of Rights and those provisions, but yet they've run roughshod over them. They don't want to allow these groups to exercise their free speech, and in particular, it's a religious free speech in these particularly in universities, and in the case of the Eighth Circuit case with the University of Iowa, the Eighth Circuit ruled that they had wrongly deregistered this religious club. And so they could choose leadership based on individual beliefs. And so what should be working, is not working, and higher education generally is running roughshod over it.
Well, Bettina, what's interesting is when you see all of a sudden you've got an administration that seems to have a department that now decides to rescind the rules, it makes you wonder, are these rules coming and going based on politics, or are they really coming and going based on what's in the best interests of the constituency? And
I think that's exactly the perception that most of us have, that the issue of free speech has, in essence, become a majoritarian rule situation. So whoever holds a political power can make the rules and limit or expand speech accordingly. So, again, let me say, this is not just a problem of the left, of an intolerant secular left. It's also a problem of an intolerant right. I mean, you see states such as Florida bringing in anti-critical race theory laws in ways that go way beyond just trying to control K through 12 curriculum. So are really trying to limit speech in significant ways. And you have many other states following suit. So, I think this is where we are. This is a challenge that we're going to be facing increasingly. How do we protect the principle of free speech without allowing it to become captive to political will? And for the past couple of hundred years, this is what has set America apart from many other nations. And we need to do all we can to hold on to that, to preserve it and protect it, because it is unique and it allows our society to be as free as it is.
Andre, I got to tell you, I couldn't help but to notice that many of the announcements that were made from the Department of Education were not done in any formal documents. They were actually done in blogs. I mean, we're actually getting to a point now where major changes, sometimes are taking place on social media. And as we know, sometimes social media will even put you in prison for a while if they don't like what you're saying. Even the communication aspect of this is getting complicated. You don't know where to even look to find out where rules and regulations are. Is there some method that we can be thinking about in order to codify things in a way that people who are even interested can actually find someplace where they can get the information?
Yeah, I think the good old days where you had to just look it up in a book are over. Anything that any edict that's posted online, written on a blog, said from a podium is now policy and expected to be followed and enforced. But I wanted to piggyback on what Bettina said about free speech. I when I cover the First Amendment in my business law class, I tell my students, the First Amendment is there to protect unpopular speech. Popular speech, by definition, requires no protection. And so, the whole idea behind this free inquiry rule is that both religious and secular groups should be required to follow the same rules and have it applied to them. And so that's the whole idea behind this. There may be unpopular speech, but it is subject to First Amendment protection. And it's interesting to note I did notice on the Education Department blog that as of yesterday, there have been no complaints that have been registered as from any universities or colleges that have violated the free inquiry rule.
I'm gonna have to let that be the last word, but it looks as though if there are no comments that are coming in, it probably is a piece of legislation that nobody actually needed to do something with. So when you wonder whether or not you make an impact, is usually depending on the voice that you get back after you actually do something. And here apparently was nothing. There's a case called the Seattle Pacific University versus Ferguson. Now, we have Seattle Pacific University was an institution that was founded in 1891. And this particular institution has been going around for quite some time, trying to figure out how to engage in cultural activities, changing the world by graduating people of competence, what they would describe as being strong character, and hopefully getting people to become more wise and what they would just generally call modeling what they called a grace-filled community. The past couple of years, Seattle Pacific has been trying to figure out how do you navigate, important conversations surrounding traditional Christian teaching on marriage and human sexuality. And not too long ago, the Washington Attorney General decided it was going to target Seattle Pacific over its religious expectations for employees and demanded that institution hand over half a decade's worth of sensitive internal employment information. You know, one of the things that you look at when you start to allow yourself to be clear on the fact that you're a religious institution or a nonprofit institution is the fact that there's certain pieces of information that do not have to be made public. And the reason it doesn't have to be made public is because you're not, quote unquote, an entity that's responsible for protecting the public in any way. Viola, when I see this case start to come down the pike, where we're now starting to find governments and other what I would call, state institutions wanting to get their hands in, take a look at information, wondering who your members are, wondering how much money you make, and even wondering what you do with the money that you make, it seems as though that's starting to become a bridge too far. Or is this something where it's not unreasonable for those requests to take place? What do you think is going on with Seattle Pacific situation here?
I think this is another cultural war issue, as Bettina has mentioned in a prior conversation here today. You have the state of California several years ago wanted to allow Christian universities and colleges only to discriminate in the hiring of theological faculty. They could not discriminate in the hiring of faculty in other areas. Traditionally, Christian universities want to hire believers that are teaching science. In other words, they're going to teach from a biblical view of origins. And so here you have a challenge to that, and it's trying to force on Christian organizations a new rule, and that's problematic in my mind, because Supreme Court has upheld in more than one case the ministerial exception doctrine, which allows Christian schools to hire teachers that are going to carry on the mission and beliefs of that church. And this is very, very concerning to me, because it looks like the state's trying to do an end around here. And sadly, the federal district court dismissed the case on procedural grounds and are leaving it to proceed in state court. I think this is a dangerous trend.
Yeah, and this is concerning for us as well here in the Pacific Northwest. Seattle Pacific University is just up the freeway from where I am. It's a Wesleyan Free Methodist university, but we also have a university here in the state of Washington, Walla Walla University, and so we have a Washington Attorney General that is launching probes into universities based on their beliefs and policies particularly on marriage and human sexuality. And there needs to be a healthy separation of church and state, and not only university, but a religious institution's ability to make its own decisions about faith, employment, and leadership. And if this university is subject to this kind of scrutiny, it can happen anywhere, to any religious school, to any institution of every faith. And the line of case law is clear. Governments cannot tell religious institutions what to believe and who should lead them. Hosanna Tabor and Our Lady of Guadalupe are two of the big Supreme Court cases that have held that. And so these cases recognize that legal principle that a religious community must be able to make its own decisions about what it believes, what it teaches, and who should lead it.
Yeah, I mean, it is interesting. Everything that Andre has said here is correct. That we in the United States, under current precedent, have protection for religious freedom for our Christian institutions and institutions affiliated with other faiths. But let's look at this in an international context. What's happening here in the US is merely a reflection of what's happening in other Western countries. I think, for instance, of a recent case in Chile where a Catholic church school was unable to make hiring decisions based on the sexual conduct of one of their staff members. And again, Australia, the country, my home country, this is an issue which has already, the horse has left the barn on this one. religious institutions have increasingly diminished ability to make those hiring and firing decisions based on codes of religious conduct. Now, all this to say that what's happening here in the US we need to engage with it. We need to be aware of it, so that we can do all we can to protect it. I agree wholeheartedly with Andre that this robust separation of church and state, preventing the government from getting its hands into the inner workings of a religious organization is absolutely fundamental for the religious free exercise of everyone, and especially those who hold what is increasingly a minority view of human sexuality.
Rashawn, I got to ask you this question. When we think about the separation of church and state, sometimes it almost seems like we're talking out of both sides of our mouths when we say, you know what, we want to make sure that the government doesn't get involved, but if there's any goodies that the government has out there, we need to make sure that we get our fair share. And on one hand, we say that, we'd like for them not to be engaged, but then there are, institutions that accept federal funding, they accept Pell Grants, they accept a number of things that would say that you are kind of related in some way. How do you draw the line in the sand here to determine when someone has gone too far or when an organization has gone too far?
I think that's exactly it. And that's really what Andre was talking about on how we, have to make sure that we are vigilant when it comes to freedom of speech and freedom of religion. Because the problem is, as we try to correct social wrongs that have happened over years in this country, which we should, we need to make sure, and that's what this Attorney General is doing, if you really look at it. What he's doing is also trying to correct what he's seen as wrongs that have happened in this country over years. And then we might extend that too far to places like our faith communities, which have a right to practice their faith the way that they want to in this country. But at the same time, you just mentioned it is something we have to be mindful. When you accept federal funds and federal dollars, there are things that go along with that that could creep into areas that you may not want them to creep into. And so we just have to be vigilant that there's a balance. There's not an overreaction one way or the other. And I think whether it's conservative or progressive, you start to see now in this climate we're in, people overreaching on both sides. And so I think it's the balancing act that the courts used to maintain, the Supreme Court. And now that people don't have faith that the Supreme Court will actually make a decision that is based on the constitutional law, you see legislatures trying to do it.
But Vilo, I got to ask this question. One of the things that's interesting, and this is what I would call one of the quiet secrets of what I would call faith in politics, is that churches and religious organizations have been given the power to discriminate. That is the long and the short of it. And the hope is that those organizations will use their power for good. Then with we as a church and other organizations, how do we ensure that we utilize this power that we get and utilize it in a way where it doesn't become being used as a sword, but we'll continue to use that power as a shield?
I think if we use it in our hiring and we use that to and our firing, we use that to continue the mission of the church and school, and if the school is making a contribution to the community in which it's in, it makes it a lot harder for politicians to target it, because they see that these are not closed-minded people. They have principles, they have convictions that they're standing on, but yet they want to make a difference. They want to be a positive influence in that community and make a difference in many different ways. I think that helps to mitigate against politicians trying to get after them.
Bettina, did you have a word you were trying to get in on that?
Yeah, that last comment really does sum up where we're at. Unfortunately, the Christian community here in the United States has gained an unfortunate reputation of taking with one hand and then demanding with the other. And we do need to make the case that we are not only entitled to religious freedom, but that we want to use that religious freedom in a way that allows us to bless our communities. And if we're not doing that effectively, then we're going to see an increasingly downward spiral in people's perception of what religious freedom is and what it means. You mentioned, Orlin, that the current Supreme Court has really changed up the whole process or the ability of religious schools, for instance, to receive funding. Last term's case, Carson versus Macon, has really just upended this whole idea of separation of church and state when it comes to the direct flow of funds to Christian schools. And when that happened, you saw the headlines in Christian media celebrating. Now all this flow of funding is potentially coming our way to support our schools. They celebrated. But on the other hand, you see a press conference from the Attorney General in Maine, which was a state in that case, saying, we're going to make sure that these funds are going to have strings attached. And sure enough, that's the approach they've taken. And it's just perpetuating this warfare and this sense of division and polarization. As Christians, as people of faith, we have a responsibility to use our religious freedom to help heal, not to help exacerbate those divisions.
And I think that's got to be the last word, the ability to use the power that you get from the courts or whomever, to use it for good and not use it as a sword that ends up really taking advantage of individuals, has to be the key in order for us to be protected moving forward. Vilo, tell me something I don't know.
The Emancipation Proclamation exempted Southern territory under Northern control from freeing the slaves.
Wow. Bettina, tell me something I don't know.
So we were talking about free speech earlier. Did you know that a recent poll showed that 99% of Americans say free speech is a fundamental constitutional value? However, when asked again in the same poll, they couldn't tell you what was worthy of protection or not worthy of protection. They said, well, what I believe is worthy of protection.
Rashawn, tell me something I don't know.
Dr. Carter G. Woodson, the founder of Negro History Week, was a part of a great fraternity, Omega Psi Phi. Since you mentioned fraternities, I thought I'd throw that one out at you.
Oh, thanks a lot. And Andre, tell me something I don't know.
The U.S. Department of Education has the smallest staff of the 15 cabinet agencies, but has the third largest discretionary budget behind defense and health and human services.
Wow. Well, listen, I appreciate that information today and look forward to talking again in the future. Thanks again for being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.